Good afternoon, everyone, and welcome to Division 5 of the Colorado Court of Appeals. My name is Judge Welling, and with me on division today are Judges Tao and Lipinski. We have one remaining case on this afternoon's docket, and that is 24 CA 1951 People v. Peters. I would just ask that everyone in the courtroom, if you have a cell phone or other electronic device, if you would make sure that it is turned off and not just muted. Just muting it continues to interfere with our recording equipment. I'd also remind everybody that there is no audio or video recording of today's proceedings. Argument is set for 30 minutes per side. Counsel will be responsible for managing your time for rebuttal. If you want any help on reserving time for rebuttal, let me know, and I'll do my level best to help you manage that time. Typically, we don't allow for tag teaming counsel, but both sides provided notice that there's a different lawyer that's responsible for the Christmas Eve motion, and we'll be arguing that. We would ask, if your plan is to present both arguments, that you figure out how you're dividing that up. But we also understand if at some point we ask a question in the middle of one lawyer's argument that's better answered by the other, both sides will have standing leave to defer to their co-counsel. And we appreciate both sides giving us notice that it was going to be handled in that fashion. I would remind everybody that these arguments are being live streamed as well as archived on our website. So to the extent there's any sensitive information, please be cognizant of that. The podium does have a toggle switch that moves it up and down, so you can put it at a level that is comfortable for you. Does anybody have any questions before we get started? Any questions?
Yes, Your Honor.
Okay.
Peter Tickton, Your Honor.
Good afternoon, Mr. Tickton.
Good afternoon. Considering it's a half hour, we don't want to use the time for the motion. I think we've said everything we need to say in the motion. So I would rather use that time for this appeal.
And that's fine. The panel may have questions about it. So if so, we'll address those. Yeah, then you'll stand. So Mr. Case will be the one that will go ahead and do the presentation of the argument. You'll just be answering questions if the division has them. Is that right?
Yes, sir.
Very good. Fair enough. Any other questions? All right, then let's go ahead and get started. Mr. Case.
Thank you, Your Honors. Good to be with you today. What is a clerk supposed to do when she suspects that the Secretary of State may be about to destroy digital election records stored on county computers that federal law requires the clerk to preserve? What should she do?
Counsel, can I just get a table setting question here? My understanding is that your contention of what the federal duty was under the federal statute is preservation of election records for 22 months. Is that correct?
Yes.
It's also my understanding that several days before anything occurred with the trusted build, one or more forensic copies of the election records had been made and retained. Is that correct?
One copy was made on May 23rd,
Okay.
2 days before the trusted build.
Okay, so 2 days before the trusted build, a copy was made and retained. And that Ms. Peters was not charged with any criminal conduct for making or retaining that copy. Am I correct?
That's correct, because it was completely legal to make the copy, which
Right,
the state
which is-
acknowledges.
Which is fine, which is why she wasn't charged. So
Correct.
why didn't that fully discharge her federal duty to the extent
Because-
that it was to preserve election records?
Sure. Because she didn't know what the government, what the Secretary of State was going to do to the county computers during this so-called trusted build.
But what would it matter if she had a forensic copy of what the computer looked like before that? that she has
Because
retained
she's
and preserved.
responsible for protecting the records, not just preserving them, but for seeing what happens to them. And she's not a computer expert. So what does she do? She knows what she knew at the time. She learned from the Dominion tech rep, David Stahl. He told her the QR code's going to be deleted. Well, why is that important? The QR code reads ballots. It processes a certain kind of ballot. So without the QR code, you can't process those ballots. That means, number one, 52 USC 20701 had been violated because that QR code was deleted. And number two, it means you can't do an audit of the prior elections without the QR code.
But why wasn't that preserved in the forensic copy that had been made 2 days before? Because isn't the forensic copy that was made an unalterable exact copy of
Yes.
what was on the system? So
Yes.
why didn't that preserve those records to be able to have that audit trail?
Well, if the QR code was there, it was preserved in the forensic image.
Right. But wasn't the forensic
She
into
still didn't know,
Oh.
she still didn't know what the Secretary of State was going to do exactly. The Secretary of State might have just deleted the QR code and left all the other data on the computers. Like when you get a Windows,
Did Ms. Peters have custody or control of that copy, of that forensic copy?
she did until it was FedExed to Hayes on the 26th or 27th.
Did she ever turn that copy over to the Secretary of State according to the record?
No,
So at all times, she had possession, custody, or control of that forensic copy.
from the time she got it and sent it to Hayes, she did. After that, he had custody of it.
But she could have gotten it back from him if she'd requested it.
Good question. I don't know the answer.
Can I roll us back just one step behind that? You acknowledge here that the argument with respect to the scope of the duty is the language of the statute, which is retain and preserve the
Yes.
records. What are we to do with the fact that at trial, when the jury instruction was requested on preservation and the court essentially raised the same question that Judge Welling just asked, is it wasn't that duty discharged? Trial counsel said, well, we're not talking about preservation, we're talking about investigation. Does the preservation argument, is that abandoned? Is it waived at this point?
No,
Why not?
because she has a duty to preserve under the federal statute. What counsel meant was, we're not talking about the imaging the system 2 days ago. We're talking about investigating what the Secretary of State's about to do to county records that are her responsibility under federal law. And
But
she has a duty to investigate that.
Where does the duty to investigate arise? It's not specified in section 20701.
Well, it's not prohibited either.
It may not be prohibited, but what gave her an affirmative duty to investigate?
Because she had to find out what was going to happen to the record she's responsible for. And she is not a computer expert. So what does she do? She asks the IT department. This is Exhibit 19.
But it sounds like you're conceding she didn't have a duty under any law to conduct the investigation. I'm looking at section 20701. I don't see any reference to investigate or investigation.
Well,
In the
doesn't,
federal
I'm
statute.
sorry, Your Honor, I didn't mean to interrupt.
Sure, I don't see a reference to it in the statute. So please help me where that legal duty came from.
Well, it's true that 20701 doesn't say investigate, but she has a duty to protect and preserve those records. So she has to find out what's going to happen to them.
But she had that. She had the forensic copy.
She had the forensic image, yes. So she needs to find out what the Secretary of State is going to do to her county records that she's responsible for.
And this is all part and parcel of your supremacy clause immunity argument. Am I correct?
Yes,
Okay, so in order to have a supremacy clause argument, you have to have a federal duty and that this was in furtherance of that federal duty,
Sure.
right? And
Yes.
you're saying that she was investigating. And I think one of the reasons the trial court rejected the supremacy clause argument is that's not within the scope of her federal obligation. And I also didn't see you continuing to advance here the investigation theory as to what she was doing. So the court, is my understanding, is the court refused that that defense on the grounds that investigation wasn't part of her obligations. Is that?
I thought what he said is she had no authority to investigate. That's my memory of it. Could be wrong, but he said you don't have any authority to investigate. But she does
Okay.
have the authority to investigate. Just like if you found out that one of your judges, a clerk came in and said, I just saw a guy show up with an envelope that had 10 $1,000 bills in it and hand it to a judge on the Court of Appeals, you would have a duty to ask more questions.
But for purposes of the immunity argument, isn't there an important distinction between whether she had authority, perhaps as the clerk and recorder, and whether she had an affirmative duty under federal law to investigate?
And to tack on to that, because if she just executed a duty but didn't commit a crime, we wouldn't be here. What she is contending is she investigated, but in the course of investigating, she violated a state criminal law. And she is contending with the immunity argument is, notwithstanding having violated the state law, I am immune from prosecution under that state law because I have this duty. So just because she can do certain things, that doesn't necessarily come within the scope of the immunity. The immunity is you were doing something that the federal statute says you have to do. And doing that made you violated the state law. The immunity doesn't extend to all things that you may be permitted to do, does it?
Well, I think it extends to finding out what's going to happen during the so-called trusted build, which turned out to be a wipe. The Secretary of State came in and deleted 29,000 files that were part of the 2020 election records and did that in 62 counties in Colorado.
Do you have any legal authority for the argument that under either Section 20701 or any federal statute, that someone situated like Ms. Peters had a duty to investigate? I'm still struggling with where that duty to investigate came from under federal law.
Because they're her records. She has to protect them. So she wants to find out what's going to happen to them. It's just like the trial court saying, well, you could have sent the machines to Denver. You could have canceled the trusted bill. That's not an option either, because if they go to Denver, she doesn't know what's going to happen to them.
My understanding is you argued below that there was a duty to investigate, and that is what triggered the supremacy clause immunity. But to us, I'm reading you as saying that it is preserve and retain that is what that duty was, and that she was carrying that out. Is it one or is it both? Or
Well, if you say that if you say that it's different to see what happens to your records than to preserve and protect them, I guess that's a difference. But she didn't see a difference.
Okay.
I got a note that I can't understand.
I think my clerks say that all the time when I give that note, so.
So there's, as Mr. Tickton has pointed out to me, there's a hard drive copy, but she needs to know what's in her computer and what's gone after the trusted build. The only way to do that is to bring an expert into the build.
But isn't a forensic copy a clone of what's on a computer, on a hard drive? It's the same thing that could be found on the election machines. So,
Well, it's supposed to be, but if you don't stand there and observe what happens during the trusted build, you don't know what happened to make the change. And that's why she needed an expert in there. So she did 5 things, 5 legal things to to fulfill her federal duty. And central to this argument is who's in charge of the premises. So the people claim that the Secretary of State is the clerk's boss and that the Secretary of State can dictate who is present during the
Counsel,
wedding.
can I push back on this just a little bit?
Sure.
Is she wasn't charged with having an unauthorized person present. As I understand it, she was on notice that the Secretary of State would not conduct the trusted build in the presence of a member of the public or somebody who wasn't an employee. And so it's not a question of whether she was authorized to bring somebody in. It's a question of whether or not she was deceptive towards a public official such that they would then choose to go forward with an activity that she was on notice that they otherwise wouldn't have. She wasn't charged with bringing an unauthorized person in.
Well,
She was charged with lying about who that was in order to get the Secretary of State to take an official action, namely actually doing the trusted build in that person's presence.
Well, Your Honor, I have a question for you. If she wasn't charged with bringing in an unauthorized person, why did the prosecutor say over and over and over in opening statement, while witnesses were on the stand and in closing argument, that she brought an unauthorized person into the room?
You can't establish again, the allegation was that the offense is based on the misrepresentation of the status of that person.
Right.
You can't establish the status of that person without talking about whether they were authorized or not,
Correct.
right? So
She brought in a person who she knew in whose presence the trusted build would not have taken place. Is that fair?
I don't understand your question.
That's
I'm
what
sorry.
I gathered that from the response on your face. She brought in somebody that she knew, if the Secretary of State was aware of who it was, the trusted build would not have occurred in that person's presence.
Well,
Is that correct?
If the Secretary of State did what they said they were going to do, yes.
Right.
So here's why it was reasonable and necessary to bring that person in,
Reasonable and necessary to what?
to perform her federal
Okay.
duty.
All right.
Okay. So she needs to see what's going to happen to the county records that she's responsible for. And what was observed by the expert that she brought in, because IT would not furnish an expert. What was observed was Danny Casillas deleting 29,000 records, files of the 2020 election, which violates the federal statute. So that's why it was necessary for Hayes to be there to see this. And she had a right to bring him in. That's no longer disputed. But during the trial, they kept saying he was unauthorized. But she authorized him to be there. And she had authority to authorize him under Rule 20.5.3B.
then why didn't she just say to the Secretary of State, I know you told me not to have anybody who isn't a county employee, but this person is not a county employee and he's going to be here because I authorize him to be here. Instead of saying, oh, no, this is a county employee, and lying about who he was.
Because if the trusted bill doesn't go down, then she can't conduct the election. That's her understanding. And then the machines will have to go to Denver and she won't be able to see what happened to him.
So in other words, she wanted to trick the Secretary of State into going forward.
She needed to in order to have Hayes present. It was reasonable because there was no harm caused by Hayes being there. The computers worked fine.
She wasn't charged with destruction of county equipment or, I mean, the harm here, the crime was that the misrepresentation of who he was led to an official act. That's the attempt to influence a public official part of this. That's what she was charged with, not that she destroyed computer equipment or did any sort of property destruction.
Well, I understand that's the people's theory, but this case was all about elections until the trial. And when the judge wouldn't allow any evidence in about elections and the people objected to any evidence about elections. But before the trial, it was all about elections. The judge found that the clerk tampered with her own equipment. He made that finding.
Based on the specific charges, which are violations of state law, how would evidence of, say, election fraud have been a defense to the charges brought under the state statutes?
I'm sorry, Judge, I don't understand your question.
So the trial court said, Ms. Peters, you can't bring in evidence that you believe there was election fraud.
Right.
How was that evidence relevant to the specific charges, which were violations of state criminal statutes?
Well, here's the relevance. The election fraud actually happened when the Secretary of State erased the 2020 election records in 62 counties. And hopefully the federal government is going to do something about that very soon.
Under what legal theory would that be a defense to the violations of the
Because
state
one
criminal
of those-
statutes?
Excuse me, Your Honor.
Please, go ahead.
One of those 62 counties was Mesa. Those are her records. And she's got a duty to prevent their destruction.
So is it a necessity defense? What is the legal nature of that defense to the state charges?
That she was performing a public duty, executing a public duty,
A public duty or a federal, or a duty under federal law?
both. She's executing a public duty. It's her job as the clerk to protect those records and to make sure she knows what's happening to her. So she needs a witness to say what is going to happen during the trusted build and what did happen.
Why couldn't that witness have been Ms. Brown or somebody who works for her?
They didn't have the technical expertise to do it.
I want to go back to the duty issue. It seems to me that the duty argument goes to immunity under the supremacy clause. But I need your help in explaining how the existence of that duty under Colorado law would have been a defense, an affirmative defense to the state criminal charges.
Well, because all she needs is a reasonable belief that what she was doing was necessary and that she used reasonable means to achieve that objective.
There's both an objective and subjective requirement of that, right? Her belief and the sincerity of her belief is necessary but not sufficient, right? It also had to
Yes.
be a
Right.
reasonable understanding of what her federal duty was, and that would be a question of law that presumably at this point it's up to us to answer. Is that fair?
Well, our position is that state courts have no jurisdiction to determine supremacy clause immunity.
Let's talk about that.
Sure.
Then who would decide that?
Federal court,
But you didn't seek to remove this to federal court, did you?
no, because she's not a person who's entitled to do that under the removal statute.
But state courts, the case law is replete with state courts resolving these questions of supremacy clause immunity, correct?
The federal cases say that the Tanella especially says state courts can't decide this.
How does a court not have not only the authority, but the duty to determine whether it has jurisdiction over the case before it?
Well, assuming you're correct, and I understand you disagree with our argument that they didn't have jurisdiction, but assuming that they have jurisdiction to decide it, then they have to follow the rules.
Oh,
And the rule is if there's a disputed fact, you have to have a hearing. No hearing was held. So the factual record to support what she did was never made. It wasn't allowed to be made.
So, but I want to go back to your jurisdictional question first, because you are contending that the state court had no jurisdiction to decide whether or not she was protected by supremacy clause immunity, right?
Yes,
Then she gets charged by the people with state law crimes,
yes,
and she contends that she is immune from prosecution under the supremacy clause.
yes.
Who decides if she's right?
And how? How does it get there?
Well, we filed a deck action in federal court, and they said the judge said, no, the state court can decide that. Your case is dismissed. 10th Circuit affirmed. So if the trial court had jurisdiction, then he needed to conduct an evidentiary hearing. which he didn't do.
So despite the fact that you filed a deck action in federal court, the federal district judge said, you're wrong, the state court can handle it. You appealed that to the 10th Circuit. The 10th Circuit said, you're wrong, the state court can handle it. You're still pursuing the argument before us that the state court couldn't handle it.
Yes.
Are you arguing that we don't have jurisdiction to consider the immunity issue?
Well, yes, but I know that you disagree with it.
Well,
so
no,
assuming that you
actually,
do-
the problem with your argument is if you're right, then we just can't decide it, and doesn't the conviction just stand? I mean, I guess I'm not sure I'm not sure you really want what you're asking for, us to
well,
decline to exercise jurisdiction, then the conviction stays. I think what you're asking us is to find that the trial court erred in its substantive determination that she didn't have that immunity, not that nobody can decide it, because you're arguing that she has it and you want us to so conclude, don't you?
Well, let me put it this way. We're not waiving the argument that state courts don't have jurisdiction to decide this. I'll call it the Tonella argument.
Okay.
But we,
Assuming that state courts do, then you need to follow the rules.
Okay.
The trial court didn't follow the rules. He didn't hold an evidentiary hearing.
I just want to stress, to follow up on Judge Welling, we have to make a threshold determination of whether we have jurisdiction. And it sounds to me like you're saying we don't have jurisdiction. And if we agree with you, as Judge Welling said, we have no choice but to conclude we have no jurisdiction, and therefore the appeal is dismissed.
Well, the trial court never had jurisdiction
Well,
either. So
I'm-
the case is gone now.
So who would tell the trial court that if not us?
Well, I think you have to.
But you're telling us
But
we
then-
don't have authority to rule. How can we tell the trial court they didn't have jurisdiction?
I'm,
Do we or do we not have jurisdiction? It's a yes or no question.
You seem to
Well,
want
if
us to give us jurisdiction
okay,
to do
if the 10th
something.
If the 10th Circuit's correct, you have jurisdiction. How's that?
Fair enough, counsel.
All right. Now, so can I turn now in the time remaining to the trial court errors?
Yeah,
Please.
absolutely.
Okay, so the law on affirmative defenses is if there's a scintilla of evidence in the record to support an affirmative defense, the trial court has to give the instruction.
Only if there's a legal basis for the defense, right?
Correct.
Would you agree that?
Right. So here there were two affirmative defenses, which the trial court decided before trial, he was not going to instruct the jury on, regardless of what the evidence was. This is page 3370 of the trial court file. He says, I'm not going to give an instruction on execution of a public duty or immunity. So no matter what the evidence was, she wasn't going to get the instruction that the Idrago and Cassell's cases say she was entitled to.
Well, that circles back to where we started, the table setting, as Judge Welling suggested. And I guess I'll just kind of recap. If the world is as premised in that question, that backing up the records with a forensic copy would preserve the records, right? And the idea being you create a forensic copy, which is a clone. Let's say, unrelated to any of the allegations, let's say the server blows up, you get a new server, you're able to replace those records with that clone, correct? That's what a forensic copy does.
Assuming that the forensic copy had all the information and assuming you could back it up, yes.
And that's not being challenged here. You're conceding that the forensic copy was a clone of.
I've never seen it, so I don't, and
Well,
one ever
whether you're
said-
conceding, you're not asserting that it wasn't. I don't see
no,
any,
I'm-
okay.
No,
So if as the premise of that question suggests, the backing up of the records preserved the records, the duty was done, what, other than that, what evidence was there to warrant the execution of a public duty defense? And I understand you don't agree that that satisfied the duty, but if it did, is there anything else in the record that would amount to a scintilla of evidence warranting the instruction?
well, she had a duty to see what happened to the records that she was responsible for. The
But-
only way to do that is to bring an expert into the trusted build. So rebuttal closing, the prosecutor tells the jury that Dr. Frank told this to the clerk. Quote, "That would be illegal, but I have the best guy in the country," close quote. So what that told the jury was, which was a misquote of the witness, by the way, but what it told the jury was Clerk Peters knew that it would be illegal to bring an expert into the room, and she did it anyway.
And this is
But
your
it wasn't
prosecutor,
illegal.
this is your prosecutorial misconduct argument, and
Exactly,
and that was not objected to when it was said. Is that correct?
correct.
Okay.
We think it meets the target test
Okay.
for
Plain
plain
error.
error.
Very good. And I just remind you, you have about 2.5 minutes left. I don't know if you want to reserve some
Thanks.
time for rebuttal.
Yes, I will.
Okay,
Thank you, Your Honor.
very good. Thank you, Mr. Case. Ms. Michaels.
Thank you. May it please the court, I'm Lisa Michaels, registration number 38949. Tina Peters was not a federal official. She was a state official who was prosecuted by the state for deceiving state and local officials so she could get an outsider into the state's trusted build process. She had a duty to preserve federal election records, but that's not what was happening here. Here, she hatched a scheme to deceive state and local officials so she could circumvent the state's security protocols for the trusted build. That's what she was charged with. She wasn't charged with copying the election server. And we don't agree that her duty to preserve records included a duty to copy the election server, but even if it did, she didn't need her plot of deception to do that.
Why wouldn't it? In fact, wasn't she instructed, or not she specifically, but didn't the messaging from the Secretary of State's office to all the clerks say, back everything up before we come? Isn't that
Yes.
how they preserve these? I mean,
Yes.
they have a federal duty to preserve records for 22 months. We have elections more often than that would warrant. So isn't the standard practice they do these backups and then they update the machinery for the next election?
Yes, I'm not sure. I want to make sure I answer your question. I agree with what you just said, but
But you seem to be hesitating to even concede that making the backup was okay, even though she wasn't charged with it. That seems a little.
well, she wasn't charged with it, and obviously I'm not the trial prosecutor, but I think we don't agree that there was that duty, that was legal for her to do that. But that's not something that she was charged with. And so for purposes of talking about it, we can say that she copied the records, but that wasn't, and so maybe we could even just assume that that met the federal duty, but I'm sorry, let me back up. So, yeah, sorry, I was on the right track. So let's say that did satisfy just for sake of argument, that did satisfy, sorry, I feel like this is a little bit sounding off. Does that sound okay to you
I think
guys?
we can hear you pretty well. Can the audience hear her? Okay, I'm getting nods, so.
Okay, good, thank you. And so, but what she didn't need to do, so her plot of deception was designed to get this outsider into the trusted build. She didn't need to deceive the state and local officials in order to copy the election server. So if we just assume that was part of her duty, she could have done that because she did do it outside of the trusted build. She did it before the trusted build occurred, and she did it after the trusted build occurred. So she had copies from what it looked like before and what it looked like after. And no one was around when those copies were made. So she didn't have to deceive. She didn't have to get those security credentials. in order
But
to do
even
that.
more to the point, she wasn't charged with any conduct related to copying before or copying after, as I understand the charges. What she was charged with was misleading members of her office and folks in the Secretary of State's office that would lull them into performing the trusted build in her presence, with full knowledge that had she been truthful, it would not have happened there in her office. Presumably, the machines would have been sent to Denver to do the trusted build. Am I missing the mark at all?
No, I agree with you. That's exactly right. She wasn't charged with making the copies. She was charged for deceiving the state and local officials.
So under the federal statute, section 20701, she had a duty to retain and preserve all records and papers relating to the election. And that presumably would include the official hard drive in Mesa County. Let's assume that the Secretary of State was in cahoots with Dominion, and Ms. Peters knew that the Secretary of State was going to monkey with the records, was going to monkey with those records she had a duty to retain and preserve. What was she supposed to do if she couldn't trust the Secretary of State?
Well, she did it. She made copies of the records, what they looked like before the trusted build
All
happened.
records and papers, whether they're copies or not, would you concede all means all? Every single copy, even if there was a forensic copy, all also included the version of that hard drive that the Secretary of State had access to. And under my, I'll call it a hypothetical, what if she knew that the Secretary of State was going to modify, illegally modify the records and papers that she had a duty to retain and preserve? What was she supposed to do?
Well, so you're saying like if there was a concern that the build would wipe out those records? Is that what I think, to me, she has the copy of what the
More
server-
than that the records would be falsified.
Well, I think having a copy of the election server before, again, we don't agree that that was permissible for her to do or that she was obligated to do that by her duty, but she had a copy of what it looked like
But
before.
all means all,
trusted
doesn't it? It
build.
means every single copy, the original, every copy of that hard drive.
As far as I know, I think we're talking about the copy that was made before the trusted build and the copy after the trusted build. Is that, just so we're on the same page, is that what we're talking about? Or do you
I
think there's another
I think
record?
all records and papers would include the records and papers that were the official election records in Mesa County that the Secretary of State was going to gain access to, right?
Yes, I think we're on the same, I think we agree.
Yeah.
I guess what I'm saying is her bringing the person into the trusted build, that was, her plot of deception was done so that she could bring that person in to observe the builds. Copying the election records before, after, whenever, that's
What should
separate.
she have done if she believed that the records are going to be illegally tampered with by the Secretary of State?
I think she could have made the copies, and not that, again, not conceding that that's legal, but there was another clerk in, I think it's Elbert County, and that's what that person did. He made copies of the election server and retained them. He was not prosecuted because he didn't engage in deception.
And I want to
public
keep going
officials.
back. You keep saying we're not conceding that she was entitled to do it. Judge Tao asked, I thought there was a directive that came out from the Secretary of State that said, before we do the trusted build, back up your records.
Oh, yes, I'm sorry. There are a couple different things at play. So there are the election records that the Secretary of State's office told her office to back up, and that all of the clerks are obligated to do that, and they did do it. And that's what one of our witnesses confirmed, that was done before that's why, and they want to do it because the update does replace the information that's on the server. And so they're required to make a copy of the election records. So there's the forensic copy, and I don't claim to be a technical expert on these issues. So the forensic copy, to the extent that it's different than those election records that the Secretary of State's office directed.
Okay,
her office
let me
to
maybe
do.
try this. The Secretary of State's office told her to copy the record, so the data. But what the forensic copy does is gets both the data and like operating software and everything. It's an entire clone. And you're not conceding one way or the other whether a full clone that included presumably some proprietary software was or wasn't legal, but it doesn't matter because she copied that, and she's not charged with having done that, regardless of whether or not you're willing to concede that that sort of copy was legal. Is that?
That's exactly
Okay.
right.
You say that she is not entitled to assert federal supremacy clause immunity at all because of who she is.
That's one of the arguments.
It is one of the arguments, but I want to test that a little bit because that's distinct from what she was doing wasn't within the scope of any immunity she might have had. That's a different thing. I mean, if your argument is she could have potentially had some immunity for some conduct, but this isn't within the scope of that. That's one argument, but I want to test the notion that she could never assert it. What if the Colorado had a statute that says election records shall be preserved for 12 months, and after that time must be disposed of, and retaining a copy of those after 12 months is unlawful. And she, as the chief election officer in Mesa County, saw that and that retaining those records is class 1 misdemeanor. She sees that statute, but she decides, I have to retain the election records for 22 months. So I have a federal obligation. I'm going to break the state law. And then when she's charged, why couldn't she say, I am acting pursuant to a federal statute, and therefore I have supremacy clause immunity for taking this conduct? Because I don't think the supremacy clause immunity is limited to federal employees or federal agents. It also, in some cases, seems to extend to people discharging a duty imposed by federal law. So would she not be able to assert the immunity under those circumstances?
So if we're setting aside the argument that you have to be a federal official, employee, or officer, if we're just talking about whether the duty would, I mean, really then the question is, was her conduct necessary to fulfill that duty? So,
And that would be a jury question, wouldn't it?
no, I mean, if we're talking about, I think you're getting at the affirmative defense, but please correct me if I'm wrong. It's not a jury question because, well, I guess, are we talking about the hypothetical, or are we talking about what actually happened? If we're talking about the facts of the case, it's not a jury question because that duty did not, the question actually for the affirmative defense is even more narrow than the supremacy clause issue, because the language of the affirmative defense, the duty or law has to require or authorize the criminal conduct. So she had to have some evidence that a duty required or authorized her to deceive state and local officials. Excuse me for just one moment.
Not entirely, right? Let's move away from the attempt to influence public servant and
Okay.
go to the official misconduct. And let me say, for the sake of discussion, the battle over the evidence of her intent conflates the concept of intent with motive. I'm going to state that as a premise. But even her motive, it may not be relevant to the official misconduct or the attempt to influence a public servant charge, because what she had to intend to do for that crime was deceive someone and affect that public official's decision. But the official misconduct charge was charged as with the intent to receive a benefit for herself. Why is it not relevant to the jury for her to say, I didn't intend to receive a benefit for myself. I intended to do what I thought was my job and protect the election process? Why was that evidence not relevant, at least to that charge?
Well, I think, and I could be wrong, my understanding was that the theory that was, and I don't know, again, I don't have the indictment right in front of me, but my understanding was that and I think actually there's the interrogatories reflect what the basis of that charge was and what the jury verdict was. And I think it wasn't based on the benefit to herself, but it was based on the violating the election, the state Secretary of State's rules. And so I think it's a little bit different. But I think it's the same idea. And those rules, by the way, just to put it out there, are about access and access to that secure room and keep maintaining logs of who's coming and going. So it's the security protocols, essentially. So, okay, sorry. And so I don't think I mean, I think it's still the same. Even if she had this motive, I think it's still, her intent is still to violate the security protocol. I mean, there are different things charged here. We have the attempt to influence, the conspiracy to commit criminal impersonation, and violating these security protocol rules. But it's really all the same. It's part of this scheme of deception. That is what she was charged. That all of it relates to that. And so her intent there, even if she had a motive, she has a motive to conceal this outsider's identity, or she has a motive to preserve whatever that she thinks she's preserving election records. She still has that doesn't take away, it doesn't negate the intent that she had. She still, because she had that motive, she had the intent to deceive, to engage in this plot of deception.
But engaging in the plot of deception has no bearing on the charge of first-degree official misconduct. And I'll have to explore the indictment a little more closely. But I was I am presently under the impression that the charge was based on the elements of that being an intent to obtain a benefit for herself
Or someone else.
or someone else. So if her argument, even if it wouldn't fly with the jury, if her argument was, my intent wasn't to benefit myself, my intent was to protect the election process, while that would have no bearing on whether the felony charges that require only an intent to deceive, the first degree official misconduct elements don't have anything to do with an intent to deceive. They have to do with an intent to gain a benefit. Why was that evidence not appropriately submitted to a jury?
I'm sorry, for the microphone, I'm sorry, if I can just have a moment to look at the jury instruction on that, because I don't have, I guess my first response without pulling this out, just to verify, is that the intent doesn't necessarily go to that benefit. It would go to the conduct. Did she intend to engage in that conduct? And so there's the intent, of course, applies to the different elements. And so it would apply to, it wouldn't negate her intent to engage in the conduct that constituted a violation of, or is this the?
So
first
here's the
degree
charge for you.
Official misconduct.
On or about the dates in question, Tina Peters, a public servant, with intent to obtain a benefit for any person. So it does directly
Oh,
apply.
no, but sorry, could you keep, so there's other, I guess what I'm getting at is what the actus reus is. And so that's the part where the intent, her intent to engage in the conduct itself.
But
violating the
again,
rules.
if there's a specific intent crime, which this is, the prosecution has to prove that specific intent. The intent to benefit, obtain a benefit for any person or maliciously cause harm to another. And she says, even if I did what I did, my intent wasn't that. And here's the evidence of that. The jury has to hear that evidence to be able to determine whether the prosecution proved the charge.
Well, the jury did hear that evidence. There was ample evidence admitted, and I cited it in the brief. I have the citations here too, if that's helpful, but that evidence did come in. I mean, the court limited it because the court was ensuring that it didn't turn into a mini trial about.
So is that a 403 ruling instead of 401 ruling? I mean, is it a
relevance?
relevance as opposed to, or is it undue prejudice?
Yes.
As opposed to 403 being undue prejudice?
And
Yes, thank
does
you.
a
I'm,
trial
I'm
court-
sorry.
Sorry, does a trial court with, you were about to make an analogy of the sideshow overcoming the circus. When it comes to a defendant's constitutional right to present a complete defense, does a trial court have the ability to curtail that in the interests of not letting the sideshow overcome the circus? Don't they have a constitutional right to present a complete defense? And the only restriction on that I think is out there is that means the court can prevent cumulative or irrelevant evidence, but it cannot curtail the presentation of relevant evidence.
Well, I think, I'm not sure if you disagree. Our argument is that the danger of unfair prejudice, confusion of the issues, or misleading the jury substantially outweighs any probative value. So that's the basis.
Is that the basis of the court's ruling?
That is the basis of the court's ruling, yes. And if we're talking about so there's no error because of that. That is the basis of the ruling. But even if there was some sort of finding that the court should have let that in, it's not a constitutional violation because she was permitted to bring some of that evidence in, and she vigorously cross-examined the evidence. It's only if she's prevented from
A complete
presenting
deprivation of
any
presenting the
exactly,
defense.
yes,
Right.
correct.
Rises to constitutional.
Is that the
issue.
Cutzinger language?
correct. Yes.
What do you do about the fact that, I can't remember that, it was actually a later proceeding in Cutzinger itself at the habeas level. Judge Kane at the federal court strongly challenged the validity of that statement, that goes way too far, that it doesn't have to be a complete deprivation, because that essentially shifts the burden to the defendant to defend their constitutional rights instead of to the people to protect them.
I'm not familiar with the continuation of that case into habeas, but I will say that wouldn't be binding on this court. We have to rely on Cutzinger because that's the case law that applies for us since we're in state court.
Can you come back to my hypothetical very briefly?
Yes.
Do you Could she have asserted under the circumstances of my hypothetical, a federal, a supremacy clause immunity defense?
Oh, right. And if you could remind me exactly, so you're saying, let me just offer if I understand. It sounds like you're saying that, I don't remember the details, but it sounds like you're saying if the state law directly conflicts
Right.
with,
Mhm.
yeah, I think if that's, again, setting aside the argument that she has to be a federal official, I think that it seems to me, I mean, again, you have to engage in the analysis of whether it was necessary. So then you're looking at, is this the only way to achieve that duty? And so, again, without remembering the specific details, and that would take us,
Okay.
pretty far afield, I think.
And
but-
maybe what but you still seem to be maintaining that she can't assert supremacy clause immunity at all. Full stop. She is not, by virtue of her position, she's just not entitled to do it. That's your first line position, right?
Yes, yes, our argument is that she has to be a federal official
Okay.
in order to assert that. But if you don't
Is-
agree with that, given the facts of this case, that she didn't need to engage in that criminal conduct, the deception, in order to.
But we only get to that question if she's able to assert it, though, right?
Yes, exactly.
Is
You
it
could
fair to
just-
say that while there may be a supremacy clause issue between the conflicting statutes, she would have an affirmative defense of the public duty, but not an immunity?
Sorry, can you say that one more time?
In his hypothetical, she might still have an affirmative defense that I was executing my public duty,
Oh,
but that doesn't mean
Yes.
she's immune.
yes, I think that would fit better in that. I mean, really if we're talking about the affirmative defense, really what that defense is available for is the situation where you have some sort of where the law says this is a crime, but then you have some other duty that requires you to do it. Like we have the case where the process server can assert that defense for the crime of trespassing. So that yes, I think the hypothetical would fit into that.
So it would be the state law affirmative defense, not the supremacy clause immunity, because you contend that it's not available to her as a state official. Fair enough?
Yeah, for your hypothetical.
If it's
if
okay
that's
with
the
my
case.
colleagues, can we turn to sentencing?
Actually, I was hoping to address the substantive charge
Okay,
of
go ahead.
conspiracy to commit criminal impersonation.
Okay.
That charge was identified in the indictment as a class 1 felony or class 6 felony under the statute subparagraph 1A. But the language of the charge actually parroted 1B,
Mhm.
which was a class 1 misdemeanor.
Correct.
And your argument is, to the extent that was error, that convicting her of a class 6 felony was error, it was harmless error because the evidence was sufficient.
Plain error, but yes.
So I want to state a hypothetical. A person is charged with second-degree murder, which is a class 2 felony under 18-3103, that they knowingly caused the death.
I'm sorry, can you just start over? I wanted to correct I got caught up because I wanted to just clarify, since harmless and plain error kind of opposite. Our argument
You're saying
is
it's
that
not reversible. That's the
correct,
key.
Correct, but under the plain error standard, not the harmless error.
That's the
standards.
key. So my point is, you're saying it's not reversible even if it's error.
Correct.
And I want to say, as a hypothetical, somebody's charged with knowingly causing the death of another under 18-3103, a class 2 felony, second-degree murder.
Mhm.
It is charged in the complaint and information, or the indictment if it was a grand jury, as homicide, citing the first-degree murder statute and calling it an F1, even though the language was of the class 2 felony. You go to trial, and there's evidence of after intent and or with intent and after deliberation, which is what makes it a first-degree murder. But they were charged with, the jury was instructed on, and the jury found guilty on the language of a class 2 felony. Is it your position that a person can still be convicted of a crime with which they were never charged and with which the jury was never instructed, as long as the evidence is sufficient?
Yes, I think that is what the case law indicates, that it's just, in this case, I'll just point out too that, I don't have the language of the statutes that you're citing in your hypothetical, but it was one word, might, and it was already.
Yeah, but that one word distinguishes it from a felony to a misdemeanor.
And
And
this case made an extra sentence, 15 more months in the Department of Corrections, that couldn't have been given had it been a misdemeanor conviction. It clearly affects a substantial right.
And I'll just say, I'm confused as to why the people are continuing to maintain that the proper remedy on this isn't to enter the conviction for the misdemeanor, because the indictment used the word might, and the jury was instructed on that, so that's what the verdict is. I am baffled as to the position that's being taken, that we can somehow overlook that and still enter the felony because the evidence that was presented at trial would have supported the felony. Are you still maintaining that position in front of us here today?
Yes, that is our position.
What
But-
case
but-
law supports that argument?
I'm sorry?
What case law supports that
I've
argument?
cited it in my brief. I don't have it right in front of me, but the case.
It's usually, it's the omitted elements
Yes,
case law,
correct.
right?
Mhm.
But that's just where the element was omitted, and but the element that was omitted wasn't in dispute. Here, the jury was affirmatively misinstructed. It was instructed on the misdemeanor, and it found her guilty of that misdemeanor beyond a reasonable doubt. This isn't the omission of an element. This is a misinstructed jury. How can we correct that by saying, no, we'll just assume that because she could have also been convicted of the felony, we enter that even though we don't have a jury verdict? That's a,
I understand it's a difficult position
Okay.
for the people to be in. But
it's not
I-
a position you have to take.
But I, thank you. But I do believe that the omitted element language applies because to me, I understand, I can hear from the way you're talking about it, it seems more egregious to add this extra word than it is to omit an element. But to me, omitting an element is a pretty big deal. And the fact that can be
Except
not
in those
reversible.
cases, at least the person was originally charged with the elemental language. Here, never on the table.
That is true, but if I can just add, and again, it seems that I will not be able to convince you, but I just want to put my argument out there, which is that there wasn't a confusion from the parties about what they were talking about because the correct statutory citation was used. So they were on notice of the statutory citation. The language was incorrect, but the statutory citation was correct.
Couldn't
there-
that also mean that the prosecution was on notice that they'd only charged, since the language was correct, they'd only charged that language and not,
Well,
both of them were on notice of something wrong.
Oh, yes. I guess what I'm saying, Your Honor, is just that there wasn't a notice problem because there was the statutory citation. And the parties treated it as though, I think it was an oversight. I think everybody believed that if they had charged and used the language that's what the record bears out, in my estimation. But I understand I'm not going to convince you. I just wanted to put
Okay.
that is the argument.
I'd like to turn to the sentencing issue. We'd like to hear argument on the sentencing issue. So the trial court in sentencing referred to Ms. Peters peddling snake oil that's been proven to be junk. She tried to undermine the election and she was weaving tails. Didn't he consider uncharged conduct as he referred, given the references to snake oil, et cetera? Wasn't he considering uncharged conduct in sentencing her, and wasn't that an error?
Well, are we talking about the First Amendment issue? I'm not sure that is, it hasn't been raised, but I understand that if it's a concern to the court. I don't think that that's something that's problematic. I mean, all of that was part and parcel of, it was the context of the criminal conduct. She wanted to promote these allegations of election fraud, and her scheme of deception, everything she did.
But
that
she wasn't convicted of publicly saying it was election fraud.
Correct, but I think because it's the context, it's relevant. I think it's something that the court can
Why
consider.
is the context relevant when the court excluded much of the evidence of election fraud? So on one hand, the judge says, Ms. Peters, you can't bring this in. On the other hand, he refers to it when he's sentencing her.
Well, and again, I know the court is aware of this, but if I just want to make sure the record is clear that he didn't exclude it entirely. He limited it. But
Right.
also she spent a great deal of time at the sentencing hearing talking about this election fraud. She used it as a platform to make all of these allegations. So of course it was relevant to what the court was doing
Well,
at the sentencing hearing. The court was entitled to consider what she said.
Well, then let's turn this as a First Amendment issue, is that the court's entitled to consider the larger context, but there's some limitations to that, right? The court cannot punish her for the exercise of her First Amendment rights. Isn't that a fair statement as a broad
Correct.
principle?
I think that's correct. I mean, if the court can consider the conduct and it may factor into the sentencing, just to break that down a little bit. I mean, I think the broad proposition is correct that we can't punish people except in these circumstances, which we're not talking about right now. But I think to the extent that it is relevant to, then the court can consider it and factor it into its sentencing
But
decision.
that's the question is does her political or personal views, is it relevant? Or is it something that is inappropriately considered? And I guess I would also frame it as, in defending the convictions and what testimony was brought in at trial and what defenses she could assert, the people very narrowly tailor this to, we're not talking about her election conspiracy stuff. We're not talking about making the copy before or making the copy after. We're talking about this very specific conduct of misleading the Secretary of State and the like. But then at sentencing, the sentencing language and the considerations end up broadening out from that considerably and getting into the very issues that you say is outside of that box that helps you defend the convictions on their merits. But my concern is that it did substantially inform the sentence that was imposed, and that creates some constitutional problems, and you don't get to ride both horses.
Well, I think it's a different forum, and that really is, I mean, the rules
It
that we
is.
have for the jury are different because
Absolutely.
and so I think that is the first part of my response. The other piece of it is, again, she made it relevant by spending, she had a slideshow. She spent pages and pages going on about this. How is the court supposed to just ignore that? I mean, of course it's going to be, the court is considering, it has all its considerations in front of it. And it referenced, it said she doesn't have any remorse. In fact, she's standing up here and doubling down on it. So I think the court, and I see that I'm out of time, so
No.
I'll finish there unless you wanted to.
No, I think this is important territory. But it's one thing to say, look, she said this and I don't agree, but then to impose additional, or to make it part of the calculation as to whether or not you're going to impose the length of the prison sentence, to me, just because she raised it means that the court can comment on it as to whether or not perhaps it's persuaded or the like. But my concern is that the court didn't say that she's engaging in all of these hoaxes and she's undermining public confidence and she's doing all of these things that I think are very detrimental to society, but I'm not considering those for purposes of sentence because she is here on these convictions and that is the exercise of her First Amendment rights. Instead, I'm going to impose the sentence based on this. So we can address it and reject it. But what my read of the transcript is, the judge considered that and it went into the calculation of the sentence, and that's a First Amendment problem. Can you disabuse me of that concern?
Well, I think the court used strong language and addressed that. I think the court, I mean, again, as I've said, it's the context, but I think if you look closely at the transcript, the court did lay all that out and then say, but at the end of the day, I think that might even be the quote. At the end of the day, this is about what you did. You violated these security protocols. You had a duty to enforce the security of the elections, and instead you violated it. So he ended up,
Well,
that was the basis of the
but
sentence.
counsel, this was not about a security breach. This was about misleading public officials to conducting a trusted build in the presence of other people. She wasn't charged or convicted with a security breach. And so that's still beyond the charged conduct and the convicted conduct. I mean, did she try to make it relevant? Yes, but the court exercised its discretion, and you say correctly, to keep that out, but then it let it inform that broader picture, inform the sentence that it imposed. I think having it both ways it fundamentally undermines or calls into question the fairness of the sentence, potentially. Why doesn't it?
I understand the concern. I do, and maybe I misspoke. I mean, I urge the court to look at the transcript because I do think the court made that distinction and talked about what she did here, deceiving. I mean, whether we call it violating the security protocols or saying she's a public servant, she's supposed to enforce this, and then here she is deceiving other public officials.
Actually, but that's my concern, is we can't just say, whether we want to call it this or that, it's still the same thing. That's not true. What was very, very important here is that what she did was brought people in, and what she was charged with was lying about who they were so something would occur in front of them. She was not convicted for bringing those people in. And so I think
Right.
that
Oh,
the
that's right.
constrained nature of what these offenses are also should inform what the sentence is that the court imposes and what conduct it considers in deciding what the appropriate sentence is.
And I apologize, maybe I'm not being clear. I am trying to focus in. I think the court was focused on the deception of these public officials, and that is what she was charged with.
But what does it matter, given the passage of time, the departure from the office, and the fact that she is still espousing them? He focused, at least for what I see as a significant part of his comments, on her continued statements. Why isn't that a problem? She's not in a position to do what she did again. There's not a specific deterrence aspect of the Stewart case cited by the people on the attorney who said they would do it again. She can't do it again. I mean, unless the people reelect her, which then question whether they want that. But this is a democratic society. So she's not in a position to do it again. Her continued belief in that, in the facts that she asserts, or the situation she asserts, has no bearing on any sentence consideration. Not deterrence, certainly shouldn't be punishment. Why should we not be concerned that he focused so much on her continued peddling of the snake oil?
I mean, I'm not saying you shouldn't be concerned, but I don't think there's an error. I think that she spent so much time talking about it. It was the backdrop of the case. There's a lot of publicity. Maybe the court felt like it had an obligation to say that it did not agree with what she was saying and that he thought the conduct was improper. But if you look at
He
what
can't sentence her more because he doesn't agree with what she's saying.
I agree with that. I'm saying, I think there's two things that happened. I think the court made some comments, and then I think the court, if you look at the transcript, talks about the basis of the sentence, which is her conduct, her criminal conduct.
And I don't blame the court for how it characterized it, given what occurred at sentencing up to that point. I mean, the sentencing argument on both sides hadn't been well tailored to the convictions or what she was tried for and convicted for. But at the end of the day, isn't the judge's responsibility to make sure to kind of separate that wheat from the chaff and only focus on appropriate considerations, or if it's wants to address those, explicitly tell us that it's not considering those in the imposition of sentence.
Maybe that would have been a better practice, and maybe we can disagree with how the court whether the court it was appropriate for a court to make those kind of comments. But I think that's a different question than whether he sentenced her based on that. And again, I think the transcript, it's very easy to focus on the very strong language that the court used. But if you look, he really did turn the page essentially and say, this is what we're here for, and this is why I'm sentencing.
And we should
this.
consider the totality of the sentencing transcript in making our evaluation, is what you're telling us, right?
Yeah.
Okay.
Exactly.
Anything else from my colleagues? All right, very good.
Okay, thank you.
If you would give 9 minutes of rebuttal to, I'm adding the additional 7 minutes that we allowed them to go over, so that it's a total of 9. And with that, Mr. Case, the floor is. Well,
Thank you,
give me just 1 second, Mr. Case. Let's get can we get a total of about 9 minutes on the clock? Perfect. Yeah, there. Just start it.
It's kind of like
Awesome.
football, reset the clock. So I like the way the court zeroed in on sentencing, because you have a 70-year-old woman, nonviolent, first offense, probation eligible, never had a traffic ticket before all this, given 9 years in the penitentiary. So under DOC regulations, she ought to be in a minimum security facility with similar defendants, nonviolent.
How do you
first
respond to the
offense.
people's argument that despite the harsh language, when you continue to read the transcript of the sentencing hearing, the court actually sentenced her based on the counts on which she was convicted?
Well, I say that's baloney. I was there. I heard the way he imposed the sentence. He was vicious. And we're asking the court, if this case is remanded, please order a different judge.
Did you raise that in your brief anywhere?
Where?
The request, I mean, that's a
Yeah,
different,
that's the relief we asked for,
Okay.
based on the fact that
Is
you
it-
denied her a free trial and sentenced her to 9 years because of what she
so if we,
was
so you're saying if we reverse and remand on the sentence, that it be resentenced in front of a different judicial
Well,
officer?
and retry.
But if it's just reversed on sentencing, it's resentencing in front of a different judicial officer is your request?
Yes, please. Your
Okay.
Honor. Okay. So I didn't know this, but until this case, but Colorado doesn't have minimum security facilities for women, just men. They have 4 minimum securities for men, none for women. So who are Clerk Peters' cohabitants in La Vista? Murderers, child molesters, drug dealers. That's the majority of the population. And why is she there? Because of what she said.
Counsel, can you address the response that, to the extent the court commented on things that she had said, it was based on the statements that she injected into the sentencing proceeding? She injected how the reasons that she was serving. I mean, she talked in her, we're looking at, I've read the whole sentencing transcript,
Right.
and she put some things in there that were also outside of the scope of what was immediately before the court. Why didn't that open the door to the court addressing the issues that she raised and the affirmative representations that she made about what her motives were and her honesty and integrity?
Well, I think Judge Tao answered that question.
Interestingly enough, I wasn't listening closely enough because I'm listening for answers to come from the podium, not next to me.
He
So
said it's-
We've been
it's-
colleagues for 15 years. It wouldn't be the first time.
Said it's up to the court to, give her a fair trial and a fair sentence and to rule justly, not bring that in when it's outside it wasn't what she was convicted of.
Fair enough.
Are you saying that the court couldn't address her slideshow presentation, her PowerPoint presentation? that the-
Sure, he could comment on it, but since she wasn't convicted of anything in it, he can't sentence her for it. The one thing that Clerk Peters did bring up at sentencing that he did consider and used as a sentencing aggravator was her prior conviction for contempt. That conviction was erased, was overturned, vacated after sentencing. So she's entitled to be resentenced for that reason alone.
and that's not an error on the court's part, because at the time that was a conviction that had validly entered. It was subsequently vacated, right?
Well, we submitted evidence at sentencing that the whole thing was a fabrication by the DA, but the judge overlooked that too.
Okay.
So I want to go back to your earlier questions on the immunity issue. So there's nothing wrong with using a false name. Anybody, you're not required to give the name that's on your birth certificate or your driver's license, unless you're doing it for fraudulent purpose. So here, there was no fraudulent purpose. The clerk introduces Conan Hayes as Jerry Wood. Now, what's the harm to the Secretary of State? None. After the Secretary of State leaves,
The harm is to Mr. Wood. It doesn't have to be harm to when there's a criminal impersonation, somebody gives a false name to avoid an active arrest warrant. The police aren't harmed. It's the person whose name was used if they're a real person.
well, Gerald Wood was not harmed. He volunteered to let Hayes use his key card. And the key card is issued so the clerk can control who's on her premises.
Well, I think that was disputed at trial, right?
Yes.
Yeah.
So 8 times during this trial, the prosecutor referred to Hayes as a cyber mercenary. Clerk Peters wanted to present evidence and tried to that Hayes had worked as a confidential government informant, that his ID had been protected in the past, that he had used alternative identities, that he was given authorization to access voting equipment for purposes of writing reports for the government, and the court wouldn't let the jury hear it.
But
In
I don't
fact,
understand how that's a defense to anything that she was charged with respect to attempt to influence a public official or the criminal impersonation.
Because there has to be an intent to deceive, and the deception has to be towards
No, there
someone.
does,
No, there
there has to
doesn't.
be an intent to alter a decision.
Right, alter a decision.
Right,
what's the
so
decision?
her intent, the decision is to conduct the trusted build in
Yes.
the presence of people that she knew the Secretary of State would not conduct the trusted build in front of.
Yes, but
That's-
what's the harm?
It doesn't need to be harmed. That's an official decision that she is attempting to influence.
Well,
In fact, if
and it
anything,
is-
the argument admits that she intended to deceive. She thinks she has a valid reason to do so. Again, I
Right.
mentioned it in questioning your opponent. You're conflating the issues of motive with intent. Elementally, for that crime, the only intent required to be proven is the intent to impact the decision of the public decision maker or of the public official. She intended to impact it. She's saying, I needed to hide his identity. She's admitting essentially doing it. She
yes,
just says she has a good reason. That's motive, not intent.
well, okay. Appreciate the distinction, but there's no harm to the Secretary of State. When the trusted bill, when the wipe is done, they do an acceptance check. Secretary of State checks it, they leave, then Dominion checks it, then.
Can you
and they-
point to me in the statute where harm is an element of this offense?
No, it's not an element of the offense.
Which is why the court ruled it was irrelevant, right?
Well, but the point is, the jury could consider harm in deciding what her intent was and what
Why?
her motives were. Why?
The jury didn't have to decide what the motives were. The motives are irrelevant.
Well,
They're not elements of the offense. They're not something for the jury to consider, are they?
yes, because she thought she had a duty to protect those records and to see what was happening to her county computers during the trusted bill. That was her job. So it was important to her that Hayes had been authorized to use false names in the past and that he had the credentials to do his job. So we submit that's why that evidence should have been allowed. The court said during the Curtis advisement, I'm not going to let her say that. I'm not going to let her testify that she knew Hayes was an informant. That's why she didn't testify and get to present her defense. Now, on the issue of sufficiency of the evidence, there were 3 counts where there is a fatal flaw when and if this gets remanded. The first is the attempt to influence Romero. It's all based on Exhibit 18, this email. There's no evidence Peters knew about the email. It was sent by Sandy Brown to Romero. She wasn't copied on it.
Wasn't that a fact question for the jury?
Well, yeah, but it's not if there's no evidence to support it.
All right,
There's
counsel,
simply no evidence she knew about the email.
very good. Your rebuttal time has expired.
Thank you, Your Honor.
Very good. Thank you, counsel, as well as members of the public. We appreciate your interest in this case and your patience this afternoon as you waited for it to be called. I think we may have started a little bit late, but I appreciate that. And I also appreciate having folks here that get to see our democracy in action and what we do in these courts. This is not, this isn't Law and Order. We're not doing the most exciting work here, but it's very important work to our democracy, and I appreciate the concern and attention that you paid to it. Thank you to counsel on both that had an opportunity to argue and who were also on the briefs. Your briefs were very helpful, as was today's argument. The case will stand submitted and a written opinion will issue in due course. And with that, we will be in recess if the bailiff will so announce.